In competition cases, and particularly in litigation cases, the role of experts is their duty is to the court. So their role is to essentially have regard to all the facts and relevant empirical and economic evidence in the case, and then express opinions on that evidence. And I guess that's in some ways a little bit different to the way competition economists might operate in competition authority-led cases, where there's more interplay, I think, between advocacy and the role of the economist in those cases. Whereas I think in courts, I think it's much more important for economists to be seen as independent, objective people whose duty is to the court. I suppose the only other thing that I would add there is, because a lot of courts are not specialised, or at least even if they are specialised, have obviously not gone through the sheer volume of casework of competition authorities. It's also an important role for experts to be able to sort of clearly articulate and set out the relevant economic frameworks for thinking about particular issues. And I think that's an area where experts probably have to work harder and do more as compared to competition authority type cases. In terms of new tools that experts are using for competition cases, I think actually it's a lot more of the case of applying a similar toolkit, but to a evolving and slightly more complex set of problems. So obviously one of the big developments probably over the last sort of 15 years that I've been practicing has been that businesses tend to collect a lot more data, and therefore there's a lot more data to analyse. Also, competition authorities tend to ask for a lot more data. So overall, the whole process is much more data-driven. That, of course, means that in litigation context, there's a lot more scope to do more complex empirical analysis and apply those empirical tools more regularly. And that obviously presents a number of its own challenges because fundamentally these tools are quite complex often. At the same time, you need to be able to explain those tools in a clear way to a non-specialist, i.e. a judge, and that obviously is a real challenge. I think the other area where it's not so much tools, but in terms of developments and the application of the same toolkit, is in and around different kinds of markets. I think we're now seeing a lot more interest in digital markets and other markets with two-sided type characteristics. Now, I'm of the view that the toolkit that one can use to assess those markets is very, very similar, but obviously applying that toolkit to those markets requires slightly different skills and a bit more thinking about how to do that. How does the enforcement of competition law differ between the EU and the UK and South Africa? Well, I suppose I moved to South Africa around about 10 years ago to open our office there, and one of the things that was sort of discussed a lot of the time was how South Africa was a little bit behind the curve as compared to Europe and the UK in terms of competition enforcement. Now, what's I think quite interesting to happen is with the growth of sort of more populist antitrust, the rest of Europe and the UK is sort of converging to some extent with South Africa, which has always been a jurisdiction that's had a greater focus on non-consumer welfare type issues, for example, around employment, but also around efficiency offences and harm to competitors, even if that doesn't result in harm to competition. Now, whether those jurisdictions end up sort of converging to the same point, unclear. I think probably unlikely. But I think one of the a potential sign of where things might be going is in South Africa. They recently changed competition law, so there's now specific recognition in competition law for buyer power, which, of course, as economists would know, generally buyer power is not a typical competition concern. In fact, you might think that buyer power is good for competition. But in South Africa now, there's specific competition law to address the existence of buyer power and often to mitigate it. Well, I think in South Africa, the main sort of developments and challenges I'm expecting to see in 2020 are those around changes to the competition law that I discussed in the answer to the previous question. So, in other words, changes around buyer power and how practitioners are going to try and balance what is something that on its face is essentially pro-competitive with the fact that that can now be an infringement of competition law. There are also other changes to the competition law around price discrimination, and in particular discrimination against different types of individuals, even if such discrimination doesn't actually harm competition. So that's in South Africa. Now, what sort of challenges do I think are going to be happening in the EU and the UK in 2020? Well, I think we're going to see more of the issues, a lot of the issues that we've been talking about today in the litigation sphere around class actions and certification and the treatment of economic evidence in those cases, but also the increasing appetite of competition authorities to undertake investigations in digital markets and to really kind of see how that intersects with a greater sense of populist antitrust, and what implications that has for markets that are just concentrated or winner-takes-all type markets where inherently populist antitrust sort of sentiment would be anti those kinds of outcomes.